It all started because I already dealt with quite a few cases regarding personal liability notices. So, and I had posted information and articles on the subject. So his current accountant actually saw my article, and because of that, he contacted me and arranged a consultation over Zoom, and Mr. Abdul Rashid was present. And it became apparent that firstly, he had a tax investigation. It took place. Secondly, that he liquidated the the company, but they hadn't been prepared or was not aware of the fact that HMRC could transfer the company penalties into the director's name. So it was a bit of a surprise to them. They didn't realize at all. And now the director had a personal debt of above over £100,000. So that was where they were when they came to me. Then I assessed it. I had a look, and even though there were 2 tax investigation consultants for unknown reasons to me, they had not submitted a tax appeal. And the original assessments were all issued in around June 2017, and they came to me January 2019. So we're talking already roughly about 2 years where no appeals had been issued, no appeals had been submitted. So normally you have a 30-day deadline. So you get the assessment or penalty assessment, you've got 30 days to submit an appeal. But in this case, I mean, it was about 2 years. So they were not our client wasn't in a very strong or robust position to be able to explain why a late appeal had been submitted. But we took the case on. We submitted an appeal direct to HMRC, which got rejected. And then we submitted an extension to that, and that got rejected. And then we had to go for tribunal, an appeal, tribunal permission to submit a late appeal. And that was on the 6th of March 2019. So they came to me in January, and by this time it's taken roughly about 3 months to get to the tribunal appeal. So at that point, I mean, when the client, our client originally came to us, he was at the point of considering selling his house because of this debt that's, seemingly just came from nowhere. They were completely surprised about it and didn't know exactly how to handle the whole situation. But it became apparent to me when we reviewed the case that there were very relevant and very reasonable explanations why it had happened as it had happened. Firstly, there was about 1 year where he had a serious accident, and he was out of commission and he couldn't manage his trade, what he was doing actively. So he was actually out of commission and he couldn't directly manage his business. So he had to leave it in the hands of others. And due to this, it just had a snowball impact as a result. So everything just came out of his control. And it led to HMRC them making huge estimations, very generalized estimations, which when you would look at it further, it just wouldn't stand a review. So it wouldn't make sense if anyone saw it from the outside. It wouldn't make sense. But the first things first is we had to be in a position where we could submit the appeal. And considering it was about 2 years late, that was the first issue. Once we got beyond that, I knew that we would be able to defend the case. And they wouldn't, I was very confident on that front. It was just getting HMRC to acknowledge the appeal, which they rejected, and then going to tribunal. So fortunately, when we got to the hearing, the way we presented it, we did it on two different fronts, because the VAT assessments and the VAT penalties, the previous consultants or specialists had actually engaged with HMRC on that front. So there was actual interaction on there, and I have no reason, I don't know why, but the consultants, the specialist in this case, took the approach of, our client only has this much to pay, will you accept it? HMRC doesn't do deals. That's not how they work. They need a reasonable basis upon which they should accept that kind of offer, and absolutely none was provided in that case. So it didn't make any sense to HMRC, and it would have, it wasn't even given any consideration by HMRC. So because of that, we had to approach it separately, because the VAT was actively engaged upon on that side, but the pay as you earn had absolutely been left out. There was no mention at it at all. It was the largest assessment at about £89,000 or so of the 3 assessments that had been issued to our client directly. And there was, throughout those 2 years, HMRC hadn't mentioned it, and the agents didn't know about it because they had not received a copy. So the previous agent had, the original accountant had received it, but they hadn't shared that information. They didn't forward the information. There was just no trace of it. So this is the reason why we had to take 2 separate approaches on the appeal. And we had, so we did it in 1 hearing, but actually it was regarding 2 appeals. So at the end of that, thankfully, we won at tribunal. Our appeal was upheld. So we were allowed to make, we were given permission to make a late appeal. And because of that, HMRC then just withdrew all the assessments as a result, because I think they realized the grounds and the balance of probability was much more stronger and robust on our client side than it was on HMRC. So we have a lot of situations like this where the director and maybe the accountant are not aware HMRC has the power to transfer penalties, company penalties, personally in the name of the director. And so we got a situation where tax assessments of very large amounts, I mean, I've had up to nearly £1 million of assessments where we've managed to successfully deal with it. But this one was the only one that we had to go to tribunal with to. But normally, I mean, HMRC are reasonable and they do accept late appeals, providing you can give a robust ground for why they should. And we've been successful with all of our other cases, but this was the only one where we couldn't, where it was rejected, and the only one we had to go to tribunal on. So there's this situation where clients are advised to liquidate their company, and then suddenly there's this huge assessment that's come out of the blue, completely blindsides them, blindsides the accountant as well, because the liquidators, who are by this time the owner of the company, they're representing the company, they're not interested in the tax assessment. They're not interested in any of this because it doesn't provide any value for them. Normally, there's no assets in the company. There's nothing to fight it with. And so it normally gets ignored. And the client may be receiving it personally, but they're told to ignore it because the liquidator is dealing with all the correspondence. And so there is this gap in between where the directors don't realize actually you are directly liable for this amount. So they can very well end up 2 years, 1.5, 2 years later on, when it goes down the bankruptcy procedure, down that route, where it starts to go down that route, then they realize, hang on, this is valid, but no one's told me about it. So we have a lot of directors in this kind of situation. And I do my best to cascade and share this information with the accounting community and company owners as well, because sometimes they're just caught completely unawares, and they could end up in a situation where they have no rights left as a result. So that's what's happened in this case, that the director was really in an awkward situation, and he was considering putting his house up for sale. in order to pay for the debt. So it had huge financial impact on our client, but we managed to successfully defend his case, where it resulted in a nil liability.